Good afternoon or good morning, everyone. You are beginning to participate in a webinar that is titled Protecting Survivors' Economic Security in Later Life, Divorce, QDROs, or Qualified Domestic Relations Orders, and coercive control. My name is Cailin Howze. I'm a retired judge and judge in residence at the National Council of Juvenile and Family Court Judges. Also joining me on this webinar are Emily Spreiser, who is the Legal Programs Director from Pension Rights Center, National Pension Assistance Resource Center. You will hear more about her organization as the webinar begins. Also with us today is Cailin Crockett. She's Program Specialist with the Administration for Community Living with the U.S. Department of Health and Human Services. And finally, Juanita Davis from the National Clearinghouse on Abuse in Later Life. Throughout this webinar, you will be hearing information as a background about the aging process, who are the folks who are susceptible to economic abuse, and also the challenges of working on improving our responses to those people impacted by this form of abuse. The webinar itself is an adaptation of a presentation that was given in 2018 at the National Council of Juvenile and Family Court Judges annual conference, and that webinar was also led by Cailin and Emily. So I think at this point we're ready to begin. I do want to tell you that the chat box is moving, but because there is so much material here for this 90-minute session, we're going to ask that you be patient, and if you have questions, they will be responded to by email after the webinar. So I guess we're ready to begin with a story. Is that correct, Cailin?
Yes, that's correct, Karen. Thank you so much for that introduction. Everyone, welcome today. It's a pleasure to have you all here and have your attention to this very, very persistent and prevalent but often invisible issue and set of survivors. I also want to say it's so important to partner across our organizations, and I'm proud of the collaboration with NCJ, FCJ, NCAL, and the Pension Rights Center, PRC, on raising awareness of the gaps in legal advocacy for older survivors when it comes to retirement and economic security in the context of divorce. So before we begin, I'd like to share a real case example from one of the attorneys supported by the Administration for Community Living, ACL, at HHS. This story, with names changed, illustrates several big themes we want to cover in the webinar today. After 40 years of marriage, Anita and Paul divorced in 2012. Throughout their marriage, Paul was controlling, emotionally abusive, and sometimes physically abusive. Paul's abuse made it very difficult for Anita to obtain and keep a regular job, so she was economically dependent on Paul and did not earn sizable retirement benefits of her own. Paul, however, was a state government employee and received a considerable monthly pension. But Paul and Anita divorced before either of them retired, and the issue of his pension never surfaced during their divorce proceedings because Paul never disclosed his retirement benefit. 6 years later, Paul was retired and living comfortably, while Anita, recently diagnosed with cancer, struggled to make ends meet between her rising healthcare costs for treatment and maintaining a household on only one income, something she had not expected to do at this time in her life. When Anita learned Paul was receiving monthly pension checks, she contacted a legal aid attorney who assisted her in obtaining a state support order through state court, requiring Paul to pay her a monthly sum, as well as an additional $1,100 each month until Paul paid down the nearly $16,000 of the pension benefit he had been receiving by himself, which should have been split with Anita. However, this arrangement required direct contact between Anita and Paul, and it was unlikely that Paul, the abusive former spouse, would actually comply with the support order. Luckily, the legal aid provider contacted the Mid-Atlantic Pension Counseling Project, which was able to advocate on Anita's behalf and obtain an additional court order that required the retirement plan to pay Anita's share of the benefit directly to her. Anita now receives her fair share of the retirement benefits directly from the retirement plan and is safe from and economically independent from Paul, her abusive former spouse. That is a real story of a survivor that our pension projects supported by HHS have helped. And there are a lot of themes that are resonant with the stories of many other survivors, many of those of whom you've encountered in your practice and advocacy. So today's learning objectives. As a result of this webinar, you will better be able to appreciate the interplay between gender, aging, and poverty, and understand how those different factors interact in a divorce context. Identify systemic risks for financial insecurity that are often experienced by older victims of domestic violence. Recognize how the event of a divorce can increase economic hardship in retirement when assets are not divided equitably. And understand how pensions and more broadly retirement assets fit into the continuum of economic justice for survivors of domestic violence, particularly survivors later in life. Consider the need for judicial oversight in ensuring that QDROs, qualified domestic relation orders, are issued and filed with the appropriate entity, and ensure that parties understand their obligations and rights when the QDRO is entered. And especially ensuring that survivors who are undergoing or have in the past gone through a divorce with an abusive spouse know their rights to spousal benefits of a pension that their spouse or former spouse may have. One of the things we want to press home today for all of the service providers and everyone involved in work that connects with older adults understands that aging is not gender neutral. What is meant by that? Well, although aging is universal, the experience affects men and women differently. Throughout their lives, women are more likely than men to experience violence from an intimate partner, be a victim of sexual assault, live in poverty, acquire a disability, and lack health care. As they grow older, the lingering effects of these disparities intensify. Older women of color, including those from immigrant communities, older women with disabilities, and older lesbian, bisexual, and trans women can face even greater or unique obstacles. This is the concept of intersectionality at play. For example, in the United States, the poverty rate for African American women aged 65 and older is nearly 5 times greater than that of non-Hispanic white men in the same age band. Rates of poverty for African American older women at 20% versus 5.3% for non-Hispanic white men in that same age band. And it should also be said that most of the sources Americans rely on for income during retirement are based on a worker's lifetime earnings, including Social Security benefits and a pension. Simply put, lower wages equal lower retirement benefits. And we all know, thinking of a lot of the people we encounter in this work in our daily advocacy, that many of the people we help are working multiple jobs, are working jobs that pay by the hour, that don't have benefits. And we also must acknowledge that women are still not paid at the same rates as men, and that those disparities are magnified for women of color. Now, economic abuse across the lifespan. Domestic violence, violence from an intimate partner, is incredibly prevalent in this country, and one of the most common forms of relationship violence comes in the form of economic abuse and control. And we've learned through good data and research that older adults who are experiencing some form of abuse, more broadly referred to as elder abuse, are very commonly experiencing economically controlling behaviors from a current or former spouse or intimate partner. All of these statistics provided for you on this slide hold up to a very powerful truth. Older adults in general, and older women more acutely, are statistically likely to experience economic abuse from an intimate partner. What does economic abuse in later life look like? Across the lifespan, at any age, an abuser may employ any of the following tactics to control the economic independence and behaviors, ability to generate their own income, how to spend the income, and how, or if it's even possible, to save income of a survivor. I won't read all these aloud. In your practice, many of you are familiar with these tactics and behaviors. But it's good to reiterate that there are many, many ways in which abusers use finances to control victims. But it's also important, and much less often discussed, that economic abuse in later life includes nearly all of those many behaviors from that previous slide, as well as many others that are related to specific financial and legal events related to the aging process. Some examples. And a particular aspect of economic abuse in later life that we want to press home to all of you today and increase your awareness of is how pensions can be taken advantage of by an abusive spouse. And so economic abuse in later life is complex for many reasons. As I mentioned, for one, older victims may experience any of the financially abusive behaviors that younger victims do. But in all likelihood, and particularly if the older adult is in a long-standing relationship or has been married to the same abusive partner for decades, they have suffered cumulative effects from a lifetime of these types of abuse. And this will impact their ability to save for retirement or to even afford basic needs. So retirement and divorce. For those who are not nearing retirement age, retirement benefits are often overlooked because they lack immediacy, even at divorce. And the process of dividing retirement benefits at divorce is complex and confusing. Many women leave money on the table that could be a potential lifeline because they don't know their legal rights to a spousal benefit. And for so many married couples, retirement benefits or an employer-sponsored pension is the only major asset that could be divided, especially as less and less Americans are able to afford owning homes. And research shows that women who depend on their current or former spouse's retirement plans are better protected under a defined benefit system. And women who have their own workplace retirement plans fare better under the defined benefit system due to economic efficiencies and plan characteristics, which my colleague Emily will go into a little bit later in this presentation. But the crux of this is, how do we make sure in all of our work that survivors, particularly those older adults who are financially vulnerable, are equipped with the knowledge they need to navigate the world of divorce and pensions? That is what we hope to communicate to all of you, service providers in the Aging Network, advocates, judges, and attorneys, over the course of this webinar and through our follow-up materials. It's now my pleasure to hand over the proverbial mic to Emily Spreiser from the Pension Rights Center.
Thanks, Cailin. Okay, so now that Cailin has laid out some really helpful context for why it's important to ensure that older survivors of intimate partner abuse have access to retirement income, we want to talk about the existing mechanisms in place for helping them obtain that retirement income, how they're deficient, and what can be done about it. First, for those of you who may not already be familiar with these mechanisms, we wanted to provide a really brief overview of how they work. And in order to appreciate why it's structured the way it is and why it has been made so complicated, it's important to get a little bit of the background and some of the legal background behind these mechanisms. So, first of all, employee benefits, including health benefits, retirement benefits, short and long-term disability, et cetera, that are provided by employers for their employees, are federally regulated under the Employee Retirement Income Security Act of 1974, or we just call it ERISA. Note that this includes benefits that are offered through unions serving private industries. They can run a plan in conjunction with many employers, but the key here is that it's private employment, so it's not government. ERISA is strictly preemptive, and what that means is that as of 1974, state governments, including judges and agencies handling divorce matters, had absolutely no power to do anything with regard to employee benefits offered by these private employers. So originally, divorce courts couldn't order the retirement benefit be split. And to understand why that is, it's important to understand why Congress made ERISA so preemptive. It was really concerned that as more and more companies were employing people across the country, and that the difficulties of making a retirement plan meet the requirements of 50 different state legal systems were going to be super costly and burdensome, that it would deplete the funding that was supposed to go toward paying people's retirement benefits, and that employers would just stop offering the retirement benefits entirely because we have a voluntary retirement system. So it created ERISA to serve as a single national framework and to prevent states from jumping in and doing some of that regulation. ERISA also contains a second provision called the Anti-Alienation Clause. And what that means is that a retirement plan cannot pay anyone other than the person who earns the benefit. It's an important protection because it protects retirees from garnishment by creditors, but this was all a problem because it prevented women who often made career sacrifices and faced career discrimination from being able to earn a meaningful retirement benefit of their own, and who had become financially dependent upon their husbands from being able to receive needed retirement income if they divorced. So, in 1984, Congress passed an amendment to ERISA called the Retirement Equity Act, and this contained many different provisions designed to make the pension and retirement system more woman-friendly. One of those provisions was an exception to the preemption and anti-alienation clauses, which stated that state courts and agencies may divide retirement benefits at divorce, but they added all of these caveats because of that original concern about states being able to subject retirement plans to 50 different laws. So they made it so that retirement benefits could only be divided through what was called, and what is called, a Qualified Domestic Relations Order, or QDRO. And I will say that even though all of this legal framework applies to private retirement plans, many government plans like state pensions or city pensions for teachers, police officers and firefighters, and the military do oftentimes have a similar framework that they've implemented themselves at the state level. But those mechanisms of QDRO equivalence go by a different name. For instance, for federal employees, for the civilians, these are known as a court order acceptable for processing, or what we call a COAP. So what are these things? What is a Qualified Domestic Relations Order? A QDRO, or Qualified Domestic Relations Order, is a domestic relations order that a state court or administrative agency with that type of power has enabled, and that has also been submitted to the retirement plan for approval and that the retirement plan has accepted, or as we say in pension lingo, qualified. They've deemed it qualified. It started as a domestic relations order. It is now accepted by the plan, and it is a qualified domestic relations order. So that's the big issue. ERISA's preemption clause exists to provide plans with this single nationwide framework to follow and to avoid subjecting plans to the laws of 50 different states. REA gave plans the ability to determine whether to accept the QDRO or not in order to protect plans from being ordered by state courts to provide benefits they wouldn't normally provide, because plans can set a lot of their own rules within the federal framework for what they will and will not pay and how they'll pay it. So as a result, it's really, really complicated. And so QDRO drafting has become a niche legal specialization that requires both knowledge of a state's divorce law and of federal retirement law. So as a result, many family law attorneys don't feel equipped to draft QDROs, and many ERISA attorneys don't draft QDROs because they don't know state divorce law. So in order to be qualified, QDROs have to meet certain basic requirements under federal law, but plans can also impose requirements on top. So federal law requires that QDROs contain certain specific information. So they have to have the name and last known mailing address of the participant and each alternate payee. So those are key terms. Participant is the person who earns the benefit. Alternate payee is the person that the plan is paying in lieu of the participant. The QDRO must contain the name of each plan to which the order applies. So if your employer offers both a pension and a 401k, it needs to specify which one. It has to have the dollar amount or the percentage, or for complicated plans, the method of determining the amount or percentage of the benefit to be paid to the alternate payee. And this, this seems like a relatively basic requirement, but you would be amazed by the number of QDROs that do not actually contain this when they're submitted to the plan and end up getting rejected. And then the number of payments of the time period to which the QDRO applies. So, is it applying for life? Are you paying these benefits until he retires and then it stops? Until she retires and it stops. You can have a time limit. I want you to pay special attention to that first bullet, the name and last known mailing address of the participant and each alternate payee. Those of you who advocate for survivors of domestic violence are probably made very nervous by that bullet, because participants in retirement plans have the right under ERISA to request documents impacting their benefit, and that includes a copy of the QDRO. So if you have this QDRO that's on file with the plan that contains a survivor's address on it because she's the alternate payee, and the participant, who is an abusive spouse, has the right to go and get a copy of that QDRO, this could create a situation where plans inadvertently disclose contact information and the current address for the victim of the person's abuse. So I've spent a lot of time, and I should say we've actually seen that happen in real life. It's not just hypothetical. I have spent a lot of time speaking with various experts in our field and retirement plan administrators. I'm not aware of any federal guidance that deals with this that requires plans to do anything about it. The employers I've spoken to that have well-run plans have indicated to me that they're willing to accept a redacted QDRO and will not reject the QDRO just because that information is redacted. And a best practice that well-run plans implement is keeping the survivor's address and other sensitive information in a separate electronic file from the bulk of the QDRO, and that's a best practice that many of the well-run larger plans implement. But there is no guarantee that every plan is doing what it should be doing and implementing those best practices. So I suggest, if you're involved in one of these cases, reaching out to the plan directly, asking them what they do to protect the client or the person you're helping's personal information from the former spouse. And if you have any doubt, use a PO box or figure out a workaround. So there are also certain things a QDRO cannot do. Federal law states that a QDRO may not require the plan to provide a type or form of benefit that it doesn't normally offer. And that's a big one because, for instance, pension plans are set up to provide monthly annuity payments. Pension plans have the option to provide benefits in the form of a single lump sum payment, but they do not have to. And so we've seen QDROs get rejected because the person drafting the QDRO didn't research the plan, didn't find out that the plan, in this case, did not offer a lump sum benefit, sent in a QDRO that demanded a lump sum benefit. The plan said, well, we don't do that, and rejected the QDRO, and they had to start all over again. So this is another area where we have seen QDROs get caught up and a significant delay in people getting the benefits that they need. It cannot require the plan pay more than 100% of the benefit earned, which includes payments of benefits that are already earmarked for another alternate payee. That's really important. So let's say you are helping someone who divorced their spouse. They delay on getting a QDRO and delay in getting that QDRO submitted. Former spouse remarries, divorces again, and that person submits a QDRO first. Well, then your client or whoever it is that you're helping might be out of luck if that entire share of the benefit has already been earmarked for that other person. You've waited too long, and now the person you're working with won't get anything. And figuring out what 100% of the benefit is in pension world can actually be a complicated process because it involves tricky math. And it cannot require survivor benefits for the alternate payee's spouse. So if we have someone who's entitled to a benefit under a divorce decree, that person remarries, you can only say that this person will receive the benefits, and you cannot say that their spouse will continue to receive the benefit, or for that matter, any other person other than that individual person who was married at one point to the participant. So that's kind of a basic overview of QDROs and how they work. And you can probably already start to see how these can actually create an access to justice problem because it is a very complicated process. So I want to talk about the 5 different hurdles through which this can become an access to justice problem. If few people really specialize in QDRO drafting, and family attorneys attempting to draft QDROs often struggle to do it correctly because they're not pension and retirement specialists, where does that leave divorce parties, particularly low-income women and women trying to escape an abusive relationship with regard to their financial future? And particularly in situations where there may be a disparity in representation and financial resources between the divorced parties. So we've identified 5 main pressure points or hurdles that divorced women have to overcome during that QDRO process. So hurdle 1 is ensuring that the divorce decree even mentions the divorce at all, or mentions the retirement benefit at all. It's our understanding that most states do require their family relations courts to consider any retirement benefits when dividing up the assets. So that is helpful, but the benefit earning spouse, especially abusive ones, don't always disclose benefits like they're supposed to. And then those benefits might never be discovered, or they get discovered much later, much long after the fact, and then it can be very difficult to go back and reopen the divorce. And oftentimes, the onus is on the person who was harmed by the lack of disclosure to prove, that she was innocent, that she didn't know, and that this actually did harm to her. So it can actually be a very daunting and difficult process to go back and get recourse. Even when everything is disclosed properly, however, people still fall through the cracks, particularly low-income, self-represented people or individuals who may have divorced through an ADR process. There are also other reasons this happens, including emotionally exhausted people leaving abusive relationships who might just not feel that it's worth fighting for the retirement benefit or that they even deserve a share of the retirement benefit. As those of us who work in this community know, domestic violence can really have an effect on your self-confidence and your feelings of self-worth. And sometimes you're so exhausted that you just don't want to deal with it anymore. And because the retirement benefit lacks immediacy, it doesn't seem worth it. So this next case example, it doesn't just come from a client. It actually comes from a dear personal friend of mine. Because I talked to her about it, she clearly had access to education about this topic and resources through me, and she still didn't want to move forward because of the psychological and emotional toll, despite all my best efforts. So of course we've changed the names and some of the details. Jane and her former husband were only married a few years, though they dated for a long time before that. Her former husband was emotionally abusive. He isolated Jane from support networks and engaged in other abusive behaviors. They had 2 small children. Jane was being treated for a debilitating illness at the same time she was caring for these 2 babies. Jane left when her former husband began overtly seeing another woman, wasn't even hiding it. He claimed he no longer found Jane attractive because of her illness, and he was frequently leaving her by herself to take care of their babies, even though she was extremely ill. Jane decided that since they had only been married a few years, that pursuing the retirement benefit wasn't prolonging the divorce and having to interact with this person any more than she needed to. So that's the first hurdle. It's getting it into the divorce decree, and it's overcoming all of these different obstacles and complications that can happen in a divorce that make people not talk about the retirement benefit. The next hurdle is understanding the need for a QDRO at all. So many women and others who may have a divorce decree might not understand that the divorce decree alone isn't enough, and they've probably never even heard the word QDRO before. This is not a household term. Again, the women who are at the greatest risk here are going to be low income and people who represent themselves pro se. Maybe they don't speak English as a first language. But we also hear all the time from women who were represented by a divorce attorney, and the attorney just never bothered to explain what a QDRO was. So there's a real opportunity here for courts and for other people working in these communities to jump in and provide public education to help individuals overcome this hurdle during and immediately after a divorce. This next case example doesn't come from any particular case per se, because this is typical of literally hundreds of cases we're familiar with. The Pension Rights Center hears this story or something very similar to it from people who seek help from us all the time. So Kate and her former husband didn't have many significant assets other than her former husband's pension, so they divorced pro se through the court's mediation process. The divorce decree divided the retirement benefit, but nobody told Kate what a QDRO was. 10 years later, when Kate stopped working and needed retirement income, she got in contact with her former husband's retirement plan and provided a copy of the divorce decree. The retirement plan informed her that the divorce decree was insufficient and she should have submitted a QDRO at the time of divorce. Now, however, it was too late because her former husband had already cashed out his entire pension as a lump sum, and there was nothing left for the plan to pay her. And I do want to interject here that you can submit a divorce decree to a plan right after the divorce, and plans will typically create a hold. It's usually 18 months while they wait for a QDRO. So if you let the plan know that a QDRO is forthcoming, they'll frequently work with you, but they're also under a legal obligation to eventually pay the benefit to the person who earned it. So they're not going to hold that forever. And the standard is typically going to be 18 months, and after 18 months, the divorce decree alone simply is not going to do the job. Okay, so that was hurdle 2. Hurdle 3 is obtaining a QDRO. We hear from women who have a divorce decree that divides the benefit, who know they need a QDRO, or at least that they need to do something, but who can't find anyone to draft a QDRO for them. And this problem is also huge. One problem is that there simply aren't many people who do it. Family law attorneys frequently refer their clients to QDRO drafting specialists, but we hear a lot from women whose attorney excluded the QDRO from representation from the get-go, told them they'd need to find someone to draft it for them, and then ended representation without providing a useful referral. There's also the issue of cost. Depending on where you are, who you're asking, and the complexity of the QDRO that needs to be drafted, the cost can range from several $100s to a few $1,000s flat fee to obtain a QDRO on top of all the other costs of a divorce. And we're not aware of any organization providing pro bono drafting assistance on a systematic basis. In situations where one party is low income but the other has money, a solution might be to order the financially well-off party to pay the cost, but what happens when both parties are low income or if the well-off party is uncooperative? There are other obstacles as well, and in the following case example, you'll see how abusers can actually leverage the QDRO process to continue tormenting the target of their abuse. This next case example is a real-life example with some details changed to protect privacy. It comes to us from the South Central Pension Rights Project, which is a nonprofit organization that the center works with and that does provide some pro bono QDRO drafting assistance to individuals in Texas. Anna's divorce decree divided her former husband's significant pension, very significant pension, and 401k benefits between them 50-50. 3 weeks after the divorce, before the QDRO was drafted, the former husband took a total lump sum distribution of his entire 6-figure 401k benefit. Anna later found an attorney willing to draft the QDRO pro bono, that would be the South Central Project, but her former husband and his attorney continued to draw out the process for several months by refusing to provide necessary documents and information while she continued to go without income. And during that time, the former husband began taking his $6,000 per month pension undivided while Anna lived in a homeless shelter. The good news here is that the South Central Project was ultimately able to get her fair share, and she is now receiving half of that pension benefit. But this went on for months, and I've cut out details for length, but this was a real doozy. For instance, the husband and his attorney were real pieces of work. He walked up to the former spouse and tried to intimidate her right in the courthouse, right in front of her attorney, trying to get her to give up her rights to the benefits. It was a pretty extreme situation, and unfortunately not uncommon. So the next hurdle is actually submitting a QDRO. So one problem is knowing how and where to submit the QDRO and meeting the plan's various submission and formatting requirements. There's also the issue of timing. As I kind of mentioned before, many women don't understand that until the QDRO is submitted, there's a risk that intervening circumstances could occur, which include the former husband taking all the money before she has a chance to submit the QDRO, the former husband marrying and divorcing again, and that other former spouse submitting a QDRO first, the former husband dying, in which case if it's a pension plan, it will treat the benefit as having been paid in full unless there is a QDRO on file at the time of death requiring the plan to pay out a survivor benefit. And if he's married at the time of death, the survivor benefit will automatically go to the new spouse unless there's already a QDRO on file reserving that benefit for the former spouse. Another obstacle is plan submission fees. They are allowed to do that. Not all retirement plans charge fees to submit a QDRO, but among those that do, the fee is usually between $350 and $400. However, our research has shown that fees can get as high as $1,800, which is way too much for a low-income person. Now, these fees are typically offset against the benefit, so they don't typically create an immediate barrier to QDRO access if the individual doesn't have the cash in hand to pay the fee up front, but it's still a problem for individuals who are low income or who just earned meager benefits because that's a very large amount of money for them. We've also heard conflicting stories. The employers that I've spoken with, and again, these are the employers who are talking to us, so they're typically the ones running really well-run plans, they've told us that they always offset the fee against the future benefit payments, so there's no immediate barrier. But I've also had judges and family law attorneys tell me that plans will still require upfront fees for them just to review QDROs prior to submission or to answer people's questions. And this is likely happening because plans are not doing their QDRO administration in-house. They're hiring third-party administrators or outside law firms to administer the QDROs for them, and then they're passing the costs of paying that outside party on to the parties, or to the retirees and the former spouses. So the following case example is a hypothetical designed to pull together the different pieces of information we've learned about this part of the process. Linda and her former partner, Sue, both work minimum wage jobs, and the only asset in the marriage was a small 401k benefit that Sue earned from a previous employer worth about $20,000. The divorce decree divided the benefits between them, so we're talking $10,000 per person. The plan's QDRO submission fee was hundreds of dollars, which would be offset against this modest benefit. Linda and her legal aid attorney asked the plan to review the QDRO before it was submitted to the plan in order to avoid having to pay the submission fee at that point, but the plan said that they would charge the fee even to review it. So they submitted the QDRO without it even being reviewed by the plan. The plan then rejected the QDRO because it wasn't properly drafted, because the legal aid attorney, as well-intended as they were, wasn't a QDRO expert. And so Linda had to go back to legal aid, get a new QDRO drafted, and submit that, and then the plan charged the second submission fee, so she's now paid the fee twice, which is again offset against the already small benefit of which Linda would have only been receiving half in the first place. And then we have our final hurdle, which is hurdle 5, and that is drafting problems and post-submission issues. So there's always a possibility things could come up after the QDRO has already been submitted. Even though plans vet QDROs to make sure they meet their requirements, it's possible that a QDRO didn't do everything it was supposed to do, and that it's gotten through the submittal and acceptance process, but still contains drafting errors that fail to protect all of the rights that the divorce decree granted to the alternate payee. A very common example that we have seen is when a QDRO fails to specify that in addition to receiving a share of the benefit earner's retirement pay while he's alive, the former spouse should also receive a survivor benefit after he dies, which requires the plan to perform a slight reduction of his lifetime benefits to reserve money for that survivor benefit. And the following real-life case example demonstrates one permutation of this very common problem. And this is a real-life case example. Mary's former husband retired and began receiving his pension while they were still married. She did not waive her right to a survivor benefit at the time of retirement, so the benefit was taken in a form that was designed to provide a survivor benefit after her former husband died. So the plan is already performing that reduction during his life to make room for that survivor benefit at the other end. They later divorced, and the divorce decree specified that she should receive survivor benefits if her former husband predeceased her. She had her divorce attorney draft a QDRO, which she submitted to her former husband's retirement plan. The plan informed her that the QDRO did not entitle her to survivor benefits because it only said that she was his beneficiary and did not specify that she should receive survivor benefits in addition to a share of his lifetime benefits. She tried to have her attorney draft a new QDRO for her, but he refused. So she's now searching for a new attorney to redraft her QDRO, which is how we found out about her because she came to us for help, and we're working on it. But this is upsetting for two reasons. One, it shows the extreme level of specificity these QDROs need to contain. And two, what's really upsetting here is that there was a survivor benefit reserved for someone, and basically it's just not going to anybody because the plan is claiming that the QDRO did not specifically order it to pay this share to her. So now that we've provided plenty of very frustrating reasons for why the current system isn't serving divorced women, we want to end on a positive note by discussing ways to help fix this problem. First, you can help by working with the divorced parties. We understand that judges' ability and the ability of others working within the court system to get proactively involved in the QDRO process may vary from jurisdiction to jurisdiction. And one thing that the Pension Rights Center hopes to understand as we continue to work on these issues is to what degree judges and courts feel they have the ability to guide parties through the QDRO process. But to the extent that it is possible in your jurisdiction, here are some ways that judges and court staff and other advocates can help parties while they're going through the divorce and QDRO process. First, you can ensure that the retirement benefits are always, always, always addressed in the divorce. And you can educate parties and court staff working with the parties about the need for a QDRO and the QDRO process and how it works so that everybody knows when they leave the divorce court exactly what they need to be doing. You can find out whether the divorce attorneys are planning to draft a QDRO, and if not, make referrals to QDRO drafting specialists. And to the extent possible, don't close out the divorce until the QDRO has been obtained, submitted, and accepted by the retirement plan to spare parties the trouble of having to go back and reopen the divorce, which can be a very daunting process later on if things don't work out. And keep an eye out for problems in general, including parties who are uncooperative about the QDRO process, since it is something that an abusive spouse can leverage in order to make the other party's life more difficult. And to the extent that you can, even review the QDRO to make sure that it's sufficient, that it does what the divorce decree is supposed to do, and that it's actually going to make a difference for the people who are involved. Another way to help is by using the Pension Rights Center as a resource. We're always happy to be a resource to judges, family court mediators, court staff, divorce attorney, advocates for survivors of domestic violence, and anybody else. So here are the three main types of services that we can provide, whether it's specific to this topic or about retirement in general. We do free trainings on ERISA, so you can invite us to offer a free tailored webinar for judges, court staff, and mediators, or whoever your audience is, on this topic specifically on retirement plans and how they work in general, which is helpful to know when you're doing the QDRO process. So use us as a resource for that. We also provide technical assistance, so you can call us to ask questions one-on-one, or you can refer attorneys or court staff to us for help understanding an employee benefits issue. We don't draft QDROs ourselves, but we can certainly explain retirement plan structure, no problem. And we can make referrals. So if you need help locating a QDRO drafting specialist, or if you have basic questions about QDROs, or if the people that you're working with need that help, or help understanding the retirement plan's rules, getting documents from the plan, understanding the value of the benefit, send them to us. If we can't answer that for them, we can refer them on to somebody else who can help. And we can sometimes locate pro bono QDRO drafters, though it is difficult. A little more about the Pension Rights Center and what we do. We're a nonprofit in Washington, D.C. Our mission is to promote and protect Americans' retirement security. We have a lot of public education materials on our website, which is actually being relaunched this year, so it will be an even more effective public education tool, I want to say midway through the year after our new website launches. And that website is pensionrights.org. We offer free legal training on ERISA. We provide technical assistance to legal practitioners on all types of retirement issues. And as I said, we do client referrals to private pension attorneys. We're also a resource center to the federally funded Pension Counseling and Information Program. You heard me mention a few of the pension counseling projects earlier with our case examples, and I know Cailin mentioned the Mid-Atlantic project when she told our opening story. So the Pension Counseling and Information Program is comprised of 6 pension counseling projects serving 30 states around the country. When we say they serve 30 states, they serve individuals living in those 30 states, but they also serve individuals whose employers are based in those states or who earned a benefit out of those states. So we can usually get somebody to a project even if they don't live in one of the 30 states, and if not, we have other resources we can refer people to. This entire program is federally funded by the U.S. Administration for Community Living, and these projects provide free legal assistance to individuals regardless of age or income if they need help involving retirement benefit. They can assist people with questions, obtaining documents and information, and their retirement plan's internal claims and appeals processes. 2 projects, which are the ones we mentioned, are able to draft QDROs in specific states, so that's New York and Texas. And then the Pension Rights Center provides backup services in the 20 states that are not covered by a pension counseling project. And to give you an idea of where the projects cover, the gray states are the states that do not have project coverage, and then the colors represent each individual project. But as I said, even if someone lives in a gray state, that doesn't mean they're out of luck, so you can refer them to us anyway, and we may be able to get them help anyway. So a final way that you can help deal with some of the frustrating issues that we've discussed today is by engaging in the Pension Rights Center's new initiative to promote retirement security among divorced women. Perhaps most related to today's topic, you can help by getting involved in this awareness raising and information gathering campaign that we're currently doing as part of our initiative. We recognize that this is a huge issue because we were receiving so many calls that were so similar to one another, and we're embarking on a project that plans to bring together various groups that are touched by the QDRO issue, and we're working together to develop and implement common ground recommendations. So right now we're doing awareness raising and information gathering, and then we're going to put on a conference later this year that brings lots of different stakeholder representatives together to brainstorm solutions to obstacles that we've identified through this process. And then we hope to establish working groups to actually begin developing outcomes and solutions. So the initiative seeks to do awareness raising and encourage dialogue among stakeholder communities through roundtable discussions and other informal discussions. We're going to culminate in a conference later this year with working groups and implementation. If you're interested in getting involved in this initiative in any way, or if you have follow-up questions for me about specific retirement or QDRO issues, you're welcome to email me. My email is espreiser@pensionrights.org. It is there on the screen, and I'm happy to answer questions. If I don't know the answer, I will find someone who does. So I also want to mention that we are planning on sending all of you a tip sheet that we have designed that is geared directly for impacted individuals. So it's meant to educate the public, but we're hoping that you can help us disseminate it. And this tip sheet is designed to help impacted individuals understand what their rights are and have a better understanding of the QDRO process to make this a little bit less daunting for them and make sure that they know how to take advantage of the rights that are available to them. So you should be receiving that soon via email. And then now I'm going to turn things over to Juanita, who is going to provide some closing remarks.
Thanks, Emily. I would one, I think there are quite a few questions we're sort of determining how we want to speak on them and check in with folks around that. But while we're waiting to hear back about how we want to go about answering those questions, I want to thank Emily and thank all of my co-facilitators today for a wonderful webinar already and for all that you all do on behalf of older survivors older survivors and older victims and older adults in your work. One of the things that, as Karen mentioned earlier, very early on in the webinar, I am Juanita Davis, and I'm the Associate Director for the National Clearinghouse on Abuse in Later Life. NCAL is also known as NCAL or NCAL. We'll respond to either. It's we are the comprehensive technical assistance provider for the Office on Violence Against Women's Abuse in Later Life grant program. And also we are the National Resource Center on Abuse in Later Life for the Office on Violence Against Women. And our mission and our vision laid together is to find a way to obviously eliminate abuse in later life and to enhance the dignity and respect of older survivors. as well as to do so in an inclusive and equitable way. So I really appreciated many of the things that were brought up today and the intersectional lens that Cailin brought to the conversation early on. NCAL is also the lead partner that is focused on older victims of crime for the Office on for OVC, the Office on Victims of Crime funded National Resource Center for Reaching Victims. And I want to thank, also reach back and say I want to thank the folks at NCJ, FCJ for all the presenters for the invitation to speak about this important topic and the impact that it can have on enhancing the safety and quality of life of all the older survivors that we work with, and hopefully we are touching as we are doing our work and you all out in your practice and in your community. On behalf of the NCAL team, I want to thank you, the participants, on the call for all that you do to enhance services and information for older survivors, and for your work to ensure that older survivors have access to those outcomes, those just outcomes as related to the critical parts here of being able to live free from harm and abuse. And certainly QDROs, as we heard today, when they are effectively executed, can play a very key role in ensuring that the older survivors receive some form of economic justice, as Cailin mentioned, that sort of it's along that continuum of economic justice that we are focusing on. And then QDROs, as you heard, are very complex. They're very nuanced in terms of the area of law that we're looking at, and the information shared in this webinar today hopefully adds to that baseline of knowledge that each of you have about the topic. And for those who are working and more familiar with it, have built on that and enhanced your knowledge and enhanced your understanding of the importance of viewing QDROs through the lens for older survivors, especially those who are at the margins. And we really kind of highlighted that area of folks as well, so that they also, everyone should be supported in this process. And I will say, as a former family law attorney who worked with survivors of domestic violence, I can affirm firsthand the importance of QDROs in that piece of the puzzle in the lives of survivors, as well as that tremendous economic, emotional and psychological toll of going through the civil legal system and of trying that resilience that is required to work through this process. As Emily states, it can't be understated, the work that you all are doing out in your communities. As we also heard today, many of the statistics and the evidence of the inequities in terms of, again, that intersectional lens of looking at folks who are at the margins of the margins, those things that are built into many of the systems that impact the survivors throughout their lives, and into the scenarios and the situations that we heard, which you all confront very likely as you work with older survivors in this context. And certainly your efforts to explore this with older survivors in your work with QDROs specifically and with the civil legal system generally, and what all that entails in terms of the rights of older survivors in the process can undoubtedly, I've seen it firsthand, it will transform, it can be transformative in the lives of survivors in terms of their ability to live free from harm and abuse. And the converse is also true, which is in terms of the negative impact or the hardship that older survivors who are retirees, who are impacted individuals, what they can face when these critical assets are not divided equitably, when we cannot live that into the lives of what we are, of the survivors we work with. And with all that in mind, I encourage you all, as you take back the information that you learned today and enhanced, hopefully, information that you are taking into your offices and into your communities, to really consider the greater impact that you can have. I also encourage you to reach out to the folks facilitating this webinar today. I really appreciate the work of the Pension Rights Center and all the things that they're doing, the information Emily shared today about what all is going on in their work and all the access to resources and support and guidance that you have. I encourage you to reach out to them to follow up, and I bet you take a look at the tip sheet. It's a phenomenal tip sheet with great resources there for you all to consider and use and to share with older survivors, so they, in fact, can be part of the informational process and gathering that understanding as to understand what you're getting into and what the opportunities are and your rights and obligations under those and within this context specifically. So I also want to encourage you all to reach out to NCAL. Our website isn't on the screen, but I will say it just very slowly. It's www.ncal.us. If you have any questions or follow-up you would like to receive or any additional information, I think it's going to go into maybe one of the resource boxes there. Again, it's www.ncall.us. We are the comprehensive TA provider for OVW around abuse in later life, and certainly this area is an area that we can offer some supplemental information and offer some supports for professionals, victim survivors, members of the public, coalitions, various entities, all the folks who are present today. We can provide you with some support and assistance. It's not referrals to, obviously, many of the folks you heard today, but we can help you as well to take action in a variety of ways to support older survivors. So as we are looking to close out, I would just quickly say, we're figuring out sort of these questions, how to respond to your questions specifically, but as a note and as a reminder for today, for this webinar, this webinar will be archived, as we've mentioned before, and you should be receiving by way of email a recording, an email with an attachment of the recording of this webinar in the coming days, certainly weeks for sure. And immediately after the webinar today, you should be sent automatically to an evaluation for the webinar. We ask that you all do, in fact, please fill out that evaluation, because we do take your comments and your comments and thoughts very seriously. Obviously, it's going to enhance the way that we all move forward and do our work as providers and in our fields and in our systems. And please, again, because this information is so critical to the safety and quality of life of many older survivors, we do ask that you share the webinar's information, that email that you do get with the recording, within your networks and outside of, as far as you can, the reach that you all have within your networks to share this information. We ask that you help us get it out there. In terms of the sort of questions around answering some questions, I will briefly end my part of the closing and let folks, Emily and other folks who you heard from before, answer maybe a few questions that we can answer here. So I'm going to hand it over back to them before closing out the webinar finally. So Emily, are you all set, or Cailin, are we all set to answer some questions? All right.
Yes, thank you. Okay, so there are a few repeat questions that I want to go ahead and answer now. So a lot of people asked about military and state governments. Yes, QDRO-like processes are available for all of those types of employers. However, they operate differently, and every state has its own rules and laws because states are self-regulating. So we're talking about 50 totally different systems, which is why I wasn't really able to get into them today. For military, I want to mention that there's a really great nonprofit organization out there called XPOSE. It's EX-POSE.org, and they represent former spouses of service members. And so they can be a really helpful resource if you have questions about obtaining retirement benefits as the former spouse of a military member. If you want to shoot me an email, I can also take your specific questions about military benefits or state government benefits and get you in touch, or reach out myself to individuals that specialize in those specific systems. They exist, but they operate very differently. We also had a few other questions I wanted to address. So let's see. Okay, so someone asked, could survivors use the address that is provided as part of a state's address confidentiality program? I do not know that 100% correctly off the top of my head. I do think it goes back to plans using best practices and being sensitive to these issues or not. In theory, I don't see any reason why that wouldn't work. On the other hand, if you get a plan that isn't sensitive, it could create some issues. Again, I can look into that. I can actually talk to some of the plan side people who have been working with me on the initiative to get their opinions on that, and I can also do a little bit more looking into what those programs actually entail and reach out to people to compare them to what the requirements are under ERISA. Let's see. So does state law or federal law dictate how long someone must be married before having access to the abusive spouse's retirement benefits? So for instance, what if the survivor seeks a divorce after a short marriage? Basically, the federal government has no say on this because divorce issues and marital issues are state issues. So the federal government gets involved with, are you forcing the retirement plan to do something it doesn't want to do? That's where the federal government is concerned. In order to get a QDRO, you have to have a divorce decree that entitles you to the benefit in the first place. So your state court, or whatever you negotiate if you're doing it through mediation, and state domestic relations law is going to determine what is and is not marital property and what share of the marital property you're entitled to. So if under your state's divorce law, the court decides that you get a pro rata share of the benefits earned during that marriage, then that's what you're entitled to under the divorce decree. And if they want to say, okay, you were married a short time, so you're only entitled to 10% of the former spouse's benefit rather than 50%, it can do that, and then the QDRO has to be drafted in a way that's consistent with the divorce decree. Unfortunately, we've seen divorce decrees that just say entitled to a share of the former spouse's benefit with nothing more specific than that, which makes QDRO drafting more difficult. So that's going to be entirely dependent upon state domestic relations law. If state law says you're not entitled to a share of these types of substantial assets when you've only been married for 6 months, then you're not going to get anything. If state domestic relations law says it doesn't matter how long you've been married, you're entitled to something, and that the court will just have to figure out what quantity is fair in these particular circumstances, then that's what happens. That goes into the divorce decree, and the QDRO is drafted based on that. And then 5, someone had asked, does it matter if the spouse is specifically listed as an alternate payee or beneficiary, or do they automatically qualify for benefits for virtue of being the legal spouse? So it's kind of tricky to answer that question. So there are only 2 people who are entitled to another person's benefit under this framework. A current spouse, which means that you're entitled to survivor benefits, and that happens automatically unless the spouse actually waives her right to the benefit. So if the plan knows you're married, it automatically gives benefits to your current spouse. A divorced former spouse is treated as a complete stranger by the plan and has none of those spousal rights, even though they were married at one point, unless a QDRO is filed, and that's why the QDRO matters. Now, if you're asking whether somebody has to be specifically listed by name, yeah, so the plan would absolutely need the person's name in order to know who to pay. But you never need to list a current spouse as an alternate payee or beneficiary. That's something that occurs automatically. It's only if you're divorced that you need to go through this whole additional rigmarole. And I should say that there are some limited circumstances where if somebody began receiving retirement benefits and got divorced after going into pay status, the former spouse may be automatically entitled to a survivor benefit in that situation, even without a QDRO, but that's in limited circumstances, and that's mainly because of kind of the bureaucracy involved in plans having to calculate survivor benefits a certain way, and since they're already reserving a survivor benefit, that might be available anyway, but that's a limited circumstance. The bright line rule is if you're a current spouse, things happen for you automatically unless you waive it. If you're not a current spouse, you must have a QDRO in order to get anything from a retirement plan. Hopefully that answers the questions. Right. So,
all right.
Well, one more thing. I mentioned, I discussed this in the chat box, but somebody had mentioned, is a QDRO only available to women leaving an abusive marriage, or can any divorced woman file a QDRO? QDROs are available to any former legal spouse. So it doesn't matter if it was an abusive relationship. It doesn't matter if you're a man or a woman. It's available in all kinds of marriages. What's going to matter here is what type of retirement plan it is. If it's a federally regulated retirement plan, you have QDRO rights. If it's a military or state plan, it's going to depend on the laws regulating that particular plan.
And Emily, one more question for you. Someone in the chat box had a good question for you to drive home the point of why QDROs are really good to do in a proactive manner when the divorce process is happening, regardless of where the person is in terms of their life stage vis-a-vis retirement. Because the question asked if a QDRO is available when it's retirement time, or if they can ask for a QDRO during divorce before retirement.
You want to get that QDRO in right away. So if you're 25 and you get divorced, get a QDRO submitted to the plan when you're 25. Because other things could happen, and like I mentioned earlier, you can get a dual in QDRO situation. So let's say you divorce your spouse, your divorce decree entitles you to a share of the benefit, you sit on it and you don't submit a QDRO, your former spouse remarries, gets divorced again, they submit a QDRO before you, that person is first in time, so they get the benefits that they're entitled to under their QDRO before you do. Or let's say this person is entitled to a 401k plan, and they've named somebody other than you as the beneficiary, and then they die. That 401k benefit is going to be automatically paid out to whoever they named as their beneficiary unless there's a QDRO on file reserving it to you. So stuff can happen between the divorce and hitting retirement age that could prevent you from getting the benefit unless the QDRO is on file, putting the plan on notice that you have a right to these benefits. So get that QDRO in as quickly as humanly possible.
And here's another good question, Emily. Do QDROs relate to the division of Social Security benefits as well, or is that a separate process?
Social Security is a separate process, which is why we did not get into that today. This presentation is specifically limited to earned retirement benefits through an employee benefit plan. Social Security is a different set of laws, different set of regulatory agencies, different set of rules, so we did not touch upon that today.
And lastly, Emily, can you go over what you mentioned about QDROs being governed by federal law, but there are specific application related to divorce law differing among the states based on their family and divorce laws?
Right. So the easy way to think of this is state law governs the divorce decree and federal law governs the QDRO. So if state law says you're entitled to a share of a former spouse's retirement benefit, the state court is going to put that in your divorce decree. Once that divorce decree is entered and final, things move over into federal territory because now you need to go to the retirement plan, which is a federally regulated entity, and you're now ordering that federally regulated entity to pay out the benefit. So state law will govern what you get in the divorce decree. The QDRO is what takes the information in the divorce decree and applies it to the retirement plan, because the retirement plan doesn't have to comply with the divorce decree because the divorce decree doesn't apply to it. It only regulates the divorce parties. So it's a separate order. It's basically a separate court order ordering retirement plan to pay out benefits. So that's the division. QDROs, because it is federal, the QDRO process is required in all states if you want to have a federally regulated retirement plan pay out a benefit that was divided at divorce directly to an alternate payee. So somebody mentioned Florida in the chat box. Okay, if you're in Florida and you are not a Florida state employee, let's say you worked for Acme Widget Corporation, or name a private corporation that you're familiar with, and you get divorced, Florida state domestic relations law is going to determine, based on their rules about marital property, how long you were married, what factors they consider when deciding what's fair, and they're going to put out a divorce decree based on that Florida state law that entitles you to X amount of your former spouse's pension benefit. You then need to obtain a second court order, this QDRO, on top of the divorce decree, which is going to go to your retirement plan. And that is the case in any state you're in. So that would be in the case in Florida, and that would be the case anywhere else. But the divorce decree might be different. If you're a state government employee, however, that's exempt from the federal laws on QDROs. A lot of states have implemented their own laws which mirror the QDRO process, but for instance, you know, they might have different rules about survivor benefits, for instance, and the states do vary somewhat depending on how their systems work. So it might look a little bit different, and they might not call it a QDRO, they might call it something else, and their submission requirements might be different. And maybe they don't do an 18-month hold. Maybe they do a 1-year hold or a 3-year hold. Like, it's a different system. It's familiar because when the Retirement Equity Act came out and created QDROs in the first place, a lot of states said, that's a good idea, we're going to do that too. But they designed it for their own processes.
All right. Thank you, Emily, and thank you, Cailin and Karen and the folks at NTJ FTJ for a wonderful, wonderful webinar. I'm going to start closing this webinar out. And on behalf of myself and my fellow presenters, I don't know you all, I got some really great information all throughout the webinar, and especially at the end there. I really appreciate everything that everyone did to make this such a phenomenal event. I want to thank each of you for attending this webinar and again for your interest in this topic. I do hope that you found the information shared with you today to be helpful in your work. One quick note that we'll be collecting all the questions that you all have put in the chat box, and we will be writing and sharing those responses with you, with the public as well. And you all will undoubtedly get access to that information. That was a question that had been asked a couple of times in the chat box. So I want to, again, thanks to everyone, to my co-presenters for sharing their expertise and information. NCJ, FCJ, thank you so much as well for your hosting this webinar, and we hope that you have a good rest of your day. Thanks again, everyone. Have a good afternoon, and see you all later.
Thank you all for joining. We're going to close out now. Please do fill out the evaluation. You'll be directed there immediately following the webinar. And there is a question on the evaluation where you can submit a request for a certificate of attendance. So if you would like one of those, please go to the evaluation link. Thank you so much.